Good morning, ladies and gentlemen, NGOs, NGBs. Welcome to the first session of the NGB workshop series. We are pleased that you can join us this morning, so let's just delve right in. My name is Delrene Liverpool Young, and I am an attorney at law, and I'm also a corporate secretary at the Office of Procurement Regulation. So at the Office of the Procurement Regulation, I advise the procurement board and I ensure that, all the policies of the organization are upheld. I also draft policies. I would have drafted the code of ethics for public bodies in Trinidad and Tobago, as well as suppliers and contractors. And I also play a role in assisting the board in achieving its strategic objectives. Prior to this role, I would have worked at the Office of the Parliament, and I would have sat on several committees that dealt with, among other things, national security, human rights, etc. This morning, we will be discussing the Non-Profit Organization Act. This act was proclaimed, and what does proclaimed mean? Proclaimed means it would have come partially into effect on April 23rd, 2019. And what does that mean? It would mean that only some provisions of this act are in force. And as such, one of my goals of this session is to really demystify the requirements of the act and to enable all the NPOs and NGOs this morning to become compliant before the stipulated deadline and the stipulated time frame of the legislation, which has recently been extended to March 31st, 2021. And we will discuss what is required for registration a little further on in the session. At this time, it would be remiss of me if I do not inform you that if you have any questions, you could place them in the chat. I am not able to see the chat at the moment, but I could assure you that at the end of the session, I would try and answer as many questions as I can. And if I don't get to your question, I give you the undertaking that I will provide email responses to same. So, what is an NPO? Well, for the purposes of the Act, a non-profit organization, which should be distinguished from a non-profit company, is an association or group of persons organized for the purpose other than to generate income or profit. Now, under this NPO Act, the NPO Act has categorized what an NPO is in two categories. And it's very important that we look at what the categories are. So firstly, the Act says an NPO is an unincorporated association, a body or group of persons, not being a legal entity, separate from persons who compose it, who come together to advance a particular purpose. Now, this in itself, in terms of this provision, what you'll see is that it's very wide. What is an unincorporated entity? Well, an unincorporated entity is an association where two people come together, two or more persons come together for a particular purpose. So if you and your friend decides to, you all want to raise some funds and to send a particular athlete overseas, you would be deemed an unincorporated association, and as such, you would fall under this act because the both of you would have come together and you would be advancing a particular purpose. So that is one category of what a non-profit organization is. The second category is the category most of us are most familiar with, and this is an incorporated association. An incorporated association really just means that you're registered with under the Companies Act, and you would have gone to the company's registry and you would have registered your organization, whether as a company, whether as a sole trader, etc. All right, and you would have registered yourself under Section 308 of the Companies Act. And that section basically just stipulates, the purposes for which you are registering. So what another component of the Act, separate and apart from the categories, would be the purpose. what is the purpose of the law will look at also what is the purpose of the NGO. So the purpose of NPOs are the advancement or promotion of a patriotic, religious, philanthropic, charitable, educational, cultural, scientific, literary, historical, artistic, social, professional, fraternal, and this is where you possibly would fall, sporting or athletic purpose, or, and this is a catch-all, some other useful object, and raises or disburses funds for that purpose or object. You would be carrying on a business without any financial or pecuniary gain to its members. So that basically just means you're not making a profit. And if you do turn over a profit, the profit goes back into the business. Another purpose of NPOs are, it restricts the use of any profits or accretions to the promotion of its purpose and object. So simply what I would have said prior. Now, why do we have this? Why do we have why the need for a nonprofit? Why the need for a nonprofit organization act in the first place, right? Why do we need a nonprofit organization act? When I looked at the legislation too, and while preparing this presentation, that was one of the questions that struck me. You know, why do we need all these new restrictions on these nonprofit organizations? Because we know that nonprofit organizations and NGOs are critical stakeholders in the national and international community, performing much needed social and cultural services, right? And we also know that NPOs have diverse structures, some operating internationally and receiving support from foreign donors, you know, and some also operate to provide relief within highly volatile areas, locally and even in conflict zones. And the answer is, the reason we have these is that the legislation is that the very noble efforts and the willingness of NPOs to engage in these selfless works makes them and you as NGBs vulnerable to abuse, including for terrorist purposes. Now, you will see that throughout this presentation, my focus is separate and apart from the nonprofit organizations on terrorist financing, and there's a reason for that. So research has shown and international experience would have identified that NPOs are vulnerable to abuse from terrorists and other criminals. And I'm going to show you three ways in which, or three categories by which NPOs could be vulnerable. Three situations that you yourself might find yourself or your directors or your organization in. And it's also something that you should be looking out for. So in terms of funding, you might end up in a situation where funds may be solicited from donors in the name of an NPO for a charitable purpose, but may instead be used for terrorist purposes with or without knowledge of the NPO. You may find a situation where funds which were legitimately raised for charitable purposes and being transferred may be diverted before actually reaching their intended beneficiary. And for those of you who listened to Minister Kojo yesterday, she made reference to the ministry distributing the funds to the NGBs, but at least complaining of not receiving the same. So sometimes, on the government side, we have to question where these funds are going, right? Another scenario could be that the NPO might be used by a donor to launder money, including terrorist funds, or be used as a legitimate front for transporting cash or other financial support from one place to another. So you may find yourself getting a large sum of money from the UK, from Serbia, from a particular country, and you would be very happy to receive the money, right? But what you don't know is that your donor actually might be laundering money. So what you need to do is you need to be able to build relationships with your donors and also find out what is the source of their funding, right? In terms of the first point, an example would have, in terms of some solicited from donors in the name of the NPO. For example, an entity may say, well, we are raising funds to host a children's event, or, you know, you might see around a particular time, Easter or maybe Christmas, you know, you go out and you say, you're raising funds to hold a football competition within the community. But instead, and you would give your money, but instead of actually using the funds for that purpose, what they do is they use the money to either purchase narcotics, they use the money to purchase weapons, they use the money to do all other sorts of things except actually have an event. Or if they do in fact have an event, they may take a small portion of the money that they would have received from the funds that they would have collected and divert some of the funds in another direction. So these are examples of how the funds which has been diverted to a non-profit organization. And when I say non-profit organization, and as I repeat that throughout the presentation, I want you to bear in mind the definition of the non-profit organization. Remember, I said it could be either an NGO where you all are incorporated, or I said it could have been 2 or more persons with a particular purpose in mind, right? So these are examples of how the funds may be abused. Another example has to do with the property owned by a non-profit organization. And non-profit organizations often own various categories of property. Property including vehicles, land, all of these things may be abused for terrorist purposes. Vehicles may be used to transport terrorist personnel, funds, weapons, and even supplies. The premises of an NPO, a non-profit organization, may also be used for the storage, the training, and or recruitment of terrorists, right? So NPOs are also vulnerable in respect of this category. And yes, this is not something that is happening overseas. From the research and from the government's perspective and the government standpoint, these are things that we are seeing happening in Trinidad and Tobago. The name of the non-profit organization may also be abused, and you have to guard in terms of your purpose and the name of your organization. So terrorists may use the guise of working for a non-profit organization in order to gain access to a region or a community. So someone in Bahrain, for example, may be very interested in cycling. And so they would probably contact the local cycling association and say, well, you know, we want to form a partnership or a collaboration with you, etc. And you might be very happy to, you know, have an international partnership. But again, these are some of the ways in which, you know, in which terrorists can travel from zones in terms of areas of conflict into our country. And they do that also, and they would have done that on your name. So they would file all their documents, their passport. You may even have to send them a letter inviting them to come to the country. But this is one of the mechanisms that they use to abuse NPOs. One example, and I have it listed here, includes funding for a hospital controlled by a terrorist organization. So a recipient of support from an NPO may also use such funds to directly or indirectly further terrorism. So this particular example, I'm not going to call the country, but a non-profit organization was actually funding a hospital and had partnerships with the state, the particular state in that country. And on the other hand, what they were also doing was that when there was any sort of warfare or any of their terrorists were injured, they would have given priority treatment to those fighters or their families. Another area is also the schools. So some NPOs have schools. They have schools and you think, well, oh, they're going into a volatile community and they're, you know, they're helping the poor and these things, and they're assisting in terms of educating. But what you're not aware of is that some of them may actually be perpetuating this false terrorist ideology, even alongside other mainstream classes. So yes, they may be teaching you math and English, but they may have a class on terrorism and warfare. And I remember when I was in law school, I had a colleague at law school who, he became an attorney at law, he was called to the bar, but then he somehow became a part of the ISIS group, and he left Trinidad because he was recruited locally, and he left Trinidad and he went overseas and he died. I saw a newspaper article not too long after where he would have died overseas. So sometimes we're not aware, and they look for the brightest and the smartest, right? So sometimes you're not aware, but some persons can be being recruited from Trinidad and Tobago. So you have to be careful, and you should always look and be aware that these things are happening around us or could happen within your organization. So these are just a few areas that NPOs may fall into prey. And like I said, you may wonder why I'm focusing on terrorist abuse, but stay with me here, as the answer is tied to the second reason as to why we have this legislation in the first place. And the second reason as to why we have the legislation, it's because of Trinidad and Tobago's obligations internationally and regionally. And what do I mean? Some of you may have heard the Attorney General refer to FATF, which is the Financial Action Task Force. You may have heard him refer to CFATF, which is the Caribbean branch of the Financial Action Task Force. But who is this Financial Action Task Force, and what are they really about? Well, they're an intergovernmental organization whose goals are to create standards and to promote effective enforcement of legal, operational measures against money laundering, against terrorist financing, and financing and the proliferation of weapons of mass destruction. So, a lot of times in the news, you hear about guns being found, and we often ask ourselves, where these guns coming from and who is bringing in these guns and how are they getting into the country, unknown to the powers that be, right? And many of us may have answers to those questions. We may have suppositions to those questions, but it's a reality that we're living with in Trinidad and Tobago. And what I will do is I will go through just very quickly the summary of CFATF's findings on Trinidad and Tobago. So CFATF had this report, the fourth round of the mutual evaluation report, and it was done in 2016. And what did that evaluation, which was conducted on Trinidad and Tobago, say? Well, the evaluation said that we were non-compliant. We were non-compliant in two recommendations, Recommendation 7 and Recommendation 8. And Recommendation 8 speaks directly to non-profit organizations. It also found that we were deficient in terms of our legal structures and our legal framework. Basically, we didn't have legislation to protect against anti-money laundering, and we didn't have sufficient legislation to combat terrorist financing or financing of terrorism, and that we were partially compliant in 13 recommendations, and we were low or moderate in all 11 immediate outcomes. So for today, I will share with you what Recommendation 8 was, specifically as it related to NPOs, sorry. So what did Recommendation 8 say? Recommendation 8 said countries should review the adequacy of laws and regulations that relate to non-profit organizations, which the country has identified as being vulnerable to terrorist financing abuse. Countries should apply focused and proportionate measures in line with a risk-based approach to such non-profit organizations to protect them from terrorist financing and abuse. So that would really answer the second reason, the second question, sorry. Like, what is the purpose of the Non-Profit Organization Act? Well, the purpose is to protect you as an NGB and as a non-governmental organization from abuse. And as I indicated before, you are vulnerable to abuse in different areas. You are vulnerable to abuse by terrorist organizations posing as legitimate entities, by concealing or obscuring the clandestine diversion of funds. So I would have mentioned before all the other areas in which you are vulnerable to abuse. So moving on, as a consequence of Trinidad and Tobago being deficient in these areas, and as a consequence of Trinidad and Tobago not having sufficient legislation in place, what happened to Trinidad and Tobago? Well, Trinidad and Tobago will lump together with countries such as Serbia, Yemen, Cambodia, etc. as non-compliant and countries with deficiencies. And these are not countries that Trinidad would really want to be allied with or in a category with, because they are very known for their terrorist activities, they are very known for tax havens, and they're very known to have loose practices in terms of money laundering. And the report actually said that one remedy would be adopting appropriate measures for non-profit organizations. Trinidad was then faced with the question of whether to comply or not to comply. But before we got to whether or not we should comply or not comply, because we were deficient, we were automatically gray listed. And when we were gray listed, that led to problems with getting international loans. The country's ratings were downgraded, right? And there was a reduction in trade. And we know that there was a reduction in trade based on the Ministry of Trade's information, right? So those deficiencies identified and failure to comply led Trinidad to being gray listed. And gray listed literally means, that the international government or bodies were sending a message to Trinidad and Tobago, because being gray listed is a warning. The next step after being gray listed is to be blacklisted. So thus the government now had to weigh its options and decide, whether or not to comply with the requirements of the recommendation, which was to put legislation in place to protect non-profit organizations or not. Not complying would have the effect of Trinidad and Tobago being blacklisted. And once you're blacklisted, your economic sanctions will follow. So when we think of economic sanctions, if you're old enough, you would remember the US having an embargo against Cuba. And you can think about what that embargo would have done to Cuba's economy in terms of it crippled Cuba's economy. So Trinidad and Tobago would have found itself in a similar situation where international countries would have refused to, based on Trinidad and Tobago being blacklisted, would have refused to engage in business with us. And this is all because we did not have legislation that would protect non-profit organizations from abuse. So it is for these reasons that we now have the Non-Profit Organization Act today, and the Act is a direct result of implementing legislative reform in this area. So we will now segue into the Act itself, and I will take you through some of the key provisions of the Act. And also we will be examining some of the new obligations or the new duties placed on NPOs and also national governing bodies. So we're going to be looking at section 3, 4, 22, 5, 8, 13, etc. We'll begin with section 3. And section 3, I won't stay very long on this because I spoke to it before. Section 3 is the interpretation section of the Act, and this really speaks to the definition of what a non-profit organization is. right? It is established, and the purpose of the nonprofit organization, established for either religious, philanthropic, charitable, educational, cultural, scientific, historical reasons, and you would be carrying out a business without financial gain to its members or officers. And it would restrict the use of the profits basically back into the operations of the organization. The only thing I would note about Section 3 is how wide in scope the section is. So Section 4, what does Section 4 say? Section 4 speaks to NPOs with a gross annual income exceeding $500,000. And if you receive $500,000 within a year, and then we look at what the meaning of gross annual income includes, you would be subject to supervision by the Financial Intelligence Unit. And what is your gross annual income? Your gross annual income is income from the provision of goods and services, your rental income if you have property, any interest or other income received from investments, any donations, any grants, any subventions received from the government, any loans that you would have taken, or any other income, whether it be cash or monetary, in terms of property or any assets acquired. So if you acquire a building, and the average cost of a commercial building in Trinidad and Tobago, depending on the location, could be anywhere from 5 million and up, or even if it's a small space, or you probably just acquire a house in the country and you're going to convert that to a property for your organization, that is more than $500,000. And as a result, you would be subject to supervision under the Financial Intelligence Unit. Bear in mind, however, though, that the financial intelligence, there are a number of organizations that receive more than $500,000 per year in Trinidad and Tobago. So the FIU had indicated, and the legislation provides, that the FIU will use a risk-based approach to determine the level of supervision required for NPOs, because not all NPOs would require such a strict level of supervision. Of course, if your income is less than $500,000, and we have a lot of smaller NGOs whose income is less than $500,000, that section would not apply to you. So let's look at Section 22. Section 22 speaks to an NPO that causes to be solicited contributions whilst not registered under the Act. So if under this legislation you do not go and register yourself as a non-profit organization, right? And remember, I spoke about being unincorporated before, where you are two persons together, perhaps doing a barbecue or a fundraiser. If you do multiple barbecues or multiple fundraisers, you will be caught under this Act, right? If let's look at the bottom line here, right? It says persons or groups who carry out a single event to raise funds for charitable purposes are exempted. So if you're doing one barbecue, the Act doesn't apply to you. Anytime you're doing more than one event, the Act will apply to you. And we know in Trinidad and Tobago, in terms of fundraising activities, we would have to do multiple fundraising activities. So this section speaks to what will happen to you if you do not comply with the Act. And by complying with the Act, remember earlier I spoke about obligations in terms of and stipulated timeframes. Compliance with this Act would have been, when I say compliance, I mean registration under this Act. There was a deadline of December 31st, 2020 to do so. However, due to COVID, the deadline had been extended to March 31st, 2021. So you have a little time, because we're in February, before March, to go and register yourself as a non-profit organization. If you don't, whilst not registered under the Act, and you go and you cause to be solicited contributions from the public or the state, you will be liable on summary conviction to a fine of $50,000. All right? A fine of $50,000. So please bear this in mind. And as Mr. Latipi said, the state will be the one with the responsibility to ask you whether or not you have been registered and to ask you about whether or not you have complied with the legislation. All right? It goes on to speak to a controller of an NPO, and we will look shortly at what the meaning of controller is, who, without a reasonable cause, contravenes this section. Right? And the controller then will be liable to imprisonment for 7 years. So it's not a fine, you're going directly to prison, right? Liable on conviction. Pardon? Well, in terms of a controller, well, I'll tell you who a controller is. We go into that. So a controller, next slide. A controller of an NPO shall ensure that proper financial accounts and records are kept. No, I don't think it's sports DT. We'll get to the definition of controller and then you'll see. So this is a record keeping function. Controller has to do with the directors of the NGOs and the NPOs and the NGOs. Yes. So, but record keeping is important. And record keeping is important because you need to have an audit trail. And also, for the purposes of any investigation, record keeping would be important. So as an NPO, you would be required to keep a listing or a register of gifts received, purchases of property, cash received, when you receive it, how much you receive, what date you received it, all the assets and liabilities, and any other thing that may be prescribed by the regulations. So in terms of now, who is a controller? So the controllers include, who is a controller of an NPO? The controllers include persons who has control or management of the non-profit organization, and includes directors, trustees, a person who is responsible for the management or administration of the unincorporated NGO. So like I said, if you are two friends and you're all doing multiple barbecues because you want to send an athlete to the Olympics, whoever is managing the money, whoever is managing the process would be deemed to be the controller of the NPO, right? It could be a senior officer of the nonprofit organization, or the NGB in your case, or the non-governmental organization. It could be a person who is not specified above, where the NPO is controlled and managed by that person. So in companies, in a lot of companies, sometimes you have what we call sleeping directors or silent directors. They're there just for the purposes of giving you the money, giving you the funds. If that person has what we call the directing mind and the control, basically the invisible hand, that person will be deemed to be the controller and the manager of the nonprofit organization. Right? Now, we remember what the requirements of the controller was, to make sure you have all your records in place, etc. We will now look at sections 14 and 18. And section 14 and 18 speaks to offenses, some of the offenses under the Act, and some of the requirements of what the controller has to do. So, non-profit organizations with annual income exceeding $10 million shall have its financial accounts audited. So where your annual, remember before we spoke about annual income of under $500,000, and what under $500,000 and above would be supervised by the FIU. Now this is an additional layer and an additional requirement. So where you receive funding in terms of exceeding $10 million, you will now be required to do audited financial statements, audited accounts, right? Your bank statements would not be sufficient. After, you could write it down, right? A controller of an NPO shall also ensure that the records of the purpose and activities of the NPO, right? The identity of its directors, senior officers and trustees, and the source of its gross annual income are kept. And here how long now? You have to keep them for 6 years. So you need to have proper record management, whether or not you back it up online, you purchase some cloud storage to do so. I could tell you under the procurement legislation, the requirement is 7 years, and if you do not have the information when we come for it, that in itself is an offense, right? So no longer is the government of Trinidad and Tobago and state entities going to accept situations where we're doing an investigation and people lighted a fire, all the documents burnt. We expect that you will have your documents in the cloud. We're living in 2021, right? A controller of an NPO who knowingly and without reasonable cause fails or contravenes section 18(1) and 2, which is the section above, would commits an offense and is liable on conviction and imprisonment for 7 years. So in law, wherever it says and, it means you get both of them. The court has the jurisdiction to give you both of them. It's not the word or. So sometimes when we see or, we'll say, well, okay, the court will have the discretion. It's either we give you a fine or we give you some years imprisonment.
Just a note, because I'm seeing the hands raised and Kevin
okay.
said we will take questions after, so
sure.
We'll take it after.
Okay, so just a reminder that I'm being advised that, we're seeing persons with questions and we're seeing their hands up. If you have a question, we'll take your questions after. But if you don't want to forget what your question is, you could put it in the chat. And at the end of the session, we will compile those questions and I will provide some responses via FAQs. So right, as I was saying, in terms of the offense, it's $50,000 and imprisonment for 7 years. It's not or, the court doesn't have a discretion. Here the legislation says and. So it will be a situation where, both things will happen. So in terms of registration, all nonprofit organizations, except for friendly societies, must now be registered. Right, and I will go through with you in terms of what registration means, and I'll also give you the necessary forms that you have to fill out in order to be registered. Now, there are two categories of nonprofit organizations, and the law basically divides them in terms of date of registration, right? So, but the provision of the Act now says no person shall operate a non-profit organization in Trinidad and Tobago unless that non-profit organization is registered under the Act. So I like to go back to my example about the two friends doing their barbecues. If you are doing multiple barbecues to raise funds, you have to go and you have to register by March 31st, 2021 under this non-profit organization act. And like I said before, I'll provide you with the forms. Now, NPOs who are currently registered under the Companies Act, because remember, under the companies legislation, there are provisions for non-governmental organizations to be registered. So you may already be registered there. Shall be deemed to be duly registered as a non-profit organization under the Act. The Registrar General shall enter the name of the non-profit company on the register of NPOs established and maintained by the Registrar General. So that big paragraph is just to say, if you are already registered under the Companies Act, you don't need to re-register under this Act. The Registrar General has a duty to now put you over on this non-profit organization list. And it is automatic. There's no additional registration. So some of you could breathe a sigh of relief if you are already registered. In terms of section 27, there is no need for non-profit companies in good standing with the company's registry, which is what I said before, to re-register as an NPO under the Act. But what you must do now is you must file and submit a completed anti-money laundering, counter financial terrorist risk assessment questionnaire to the Registrar General. I also would provide you with a copy of this risk assessment questionnaire, right? So the risk assessment questionnaire will ask you certain questions in terms of how exposed are you, it will ask you in terms of what are some of your activities, where do you get your funding from, whether or not you know your client. So it's very much like when you go to the bank and you're trying to open an account and the bank asks you certain compliance questions, you know, how much money you're making, where you're getting it from, what you're going to do with it, how much money you expect to come into the account. It's similar to that. We call it the risk assessment questionnaire. So if you're registered already, you don't have to re-register, but you do have to fill out this questionnaire and submit it to the Registrar General's office. So non-profit organizations, other than the ones who are registered under the Companies Act, in operation immediately before the 14th of June, 2021, may continue to carry out their activities without registration under the Act for a period of 18 months. Now, this is what the section in the Act says. It shouldn't be 2021, sorry, it should be 2019 because the Act came into force in 2019. So from 2019, you would have had 18 months by which to register. So that would have brought you up to either June, December, thereabouts. And because of COVID, the government would have extended that deadline until March 31st. So so nonprofit companies who have been operation and not registered, you have until March 31st, 2020 to get registered, right? March 2021, yeah, March 31st, 2021. And this was provided in an order by the president. So what do you need to register as an NPO? Well, you need a completed registration form, a Form 1, which I would give you. You would also need a completed anti-money laundering CFTPF risk assessment questionnaire, which I will also provide. You would need a copy of the certificate of incorporation of the NPO. If you have a constitution or if you have any bylaws, they would require those. You would need a copy of photo identification of the controller of the NPO. And remember what we said the definition of controller was. If you're a trustee, if you're a director, if you're a manager, if you're an administrator, copies of the identification. And you need a copy of a letter of approval or exemption from corporation tax, where applicable. Issued to the NPO. So sometimes NPOs come for funding, and because we know the law says, they may be exempted in certain circumstances if they're providing, certain services. They think they don't need to come with their exemption certificate. But the law requires that even though you're not paying VAT in certain circumstances, that you get a certificate saying you don't have to pay VAT. That is the state's check on your organization. So that's what you would need to register. So a lot of what I spoke about before, and it should be noted that many of the areas that we just discussed above prior are also subject to criminal offenses under another piece of legislation that we call POCA for short. The meaning is the Proceeds of Crimes Act, right? These include money laundering. So if as an NGO you're caught money laundering under the POCA, it's $25 million, $25 billion, sorry. No, 25 million, right? Yes, million. Million and 15 years imprisonment. That's the fine if you're caught, right? So now what would happen is you would be, when the police charging you, they're going to charge you under the two legislations, right? So you'll end up having multiple charges. So sometimes you hear about entities with 15 and 16 charges behind their names. This is why. Because there are different pieces of legislation that create different types of offenses, and this is why. So failure to disclose knowledge or suspicion of money laundering, $250,000 and 3 years imprisonment. So if you're receiving funding from an international donor, or even from, funding from somebody in Trinidad and Tobago, and you don't question them in terms of, where they get their funding, how they get their funding, but you have an inclination, you say, well, this person have a 9-to-5 job, right? But could donate millions of dollars to me. You have to question where they get any money from, right? Sometimes, we sometimes call them community leaders. Community leaders, they might have a business or they may not have a business, but they're funding organizations within the communities. And remember, again, the definition of a non-profit organization is not only a non-governmental organization, but again, my example, the two friends with the barbecue, or the two friends raising funds for somebody with a medical issue and you want to send them overseas for surgery. All of those are non-profit organizations, right? So the point here is that you basically need to know where the person's fund is coming from. Attorney General likes to say, follow the wealth. Well, you as the NPO, the responsibility and the obligation is now on you to find out where the money is coming from before you use it. Because if you use it, this will be the consequence once you're convicted and you're found out. If you're financing terrorism, if you're an NPO or an NGB and you're taking money and from the government and you're saying that, I helping the cyclists in my community, I helping the swimmers in my community, I helping the runners in my community or the boxers, and in fact, or you have a little program in the community center for the youths, or even like a football match, and when you take that funds, you're probably just doing one event for them, and then you take that funds and you're looping them in, and you're encouraging them to join gangs, or you are encouraging them to participate in illegal activities, then you would be liable, right? There's a definition for terrorism, but it's pretty wide, but it will capture all of the examples that I just gave. And you have to also bear in mind the recent legislation in terms of the anti-gang legislation. So you'll find definition of terms there also. Failure to make a suspicious transaction report to the FIU. So if you, like I said before, you are aware or you just become suspicious about it and you don't make a report, or you don't inform. I remember when I was in school, people used to say informer for dead. Well, if you don't inform, $500,000 and 2 years imprisonment, right, on a summary conviction. And if you end up in the High Court on indictment, 7 years. 7 years. So as you will see, the offenses that have been created in these areas are pretty onerous and pretty strict. So what I've done is, I know that some of you will have a lot of questions, so I tried to, anticipate some of the questions, right? So if your question doesn't fall within this category, and I'll make these slides available, and I'll also make the FAQs available to you, you can ask me after. So if I want to operate an NGO, an NPO, a non-profit organization in Trinidad and Tobago, what do I need to know? Well, you need to know that this Non-Profit Organization Act exists, and it says that no person is permitted to operate an NPO in Trinidad and Tobago unless the NPO is registered under the Act. So we would have also touched on, covered that prior, right? Another question is, where do I go to register? So after I give you the forms, etc., where do you go to register? Well, you could either register, at any of the Registrar General's branches. Government Campus Plaza, which is obliquely opposite Hyatt, Pennywise Building in Arima, upstairs Pennywise Building, Leoto Street, San Fernando, if you're from South, and even in Tobago, Caroline Building, Tobago, Scarborough, Tobago. So these are some places where you could go to register yourself as a non-profit organization. So what about unincorporated bodies and non-profit companies incorporated by an Act of Parliament? So some companies are incorporated by Acts of Parliament, some religious bodies, some, right? Some sporting organizations. So in case of unincorporated bodies of persons or a non-profit company incorporated by an Act of Parliament, which falls within the definition of NPO, the controller must apply to the Registrar General to be registered as a non-profit organization by submitting the following documents. So companies registered and NPOs registered as by an act of parliament is different from being registered from under the Companies Act. Because remember, prior I would have said that those registered under the Companies Act, it would be an automatic registration for them under this act. But for those established under an act of parliament, you have to do your registration as if you weren't registered before. So you have to fill out your registration form with your name, your address, telephone number, email address. You have to declare the purposes and activities of the nonprofit organization, because by an act of parliament, it's done pretty briefly. You have to name the occupation and address and telephone number of each person who is a controller of the NPO. So it's not just one person. If you're a board, or even just like I said, it's multiple friends, or you're just a group, you have to name everyone, right? You would need copies of the constituent documents of the NPO in terms of, well, you're coming with your act of parliament, you're coming with your incorporation document, you're coming with your photo identification, the usual, and an application fee. The application fee is just $100, and it's a non-refundable application fee. So, can an NPO registration be cancelled for any reason? And the answer is yes. The Registrar General could take it upon herself to determine, based on these reasons, to cancel the registration. And these reasons include the NGO would have failed to keep proper financial records as prescribed. So cancellation would mean that you would no longer be able to operate as you are currently operating in Trinidad and Tobago, right? You would have failed to submit your audited financial accounts and records as prescribed. So if you remember, audited financial accounts would have only been necessary where you're receiving $10 million and above for the particular year. If it is proven in a court that the non-profit organization breached a duty owed to itself or any of its contributors. So non-profit organizations, just like companies, have fiduciary duties, right? What are fiduciary duties? Well, you're supposed to be acting in the best interest of the company. You're supposed to be acting in the best interest of the organization. Acting in the best interest of the organization is not acting in the best interest of its directors. So if your directors receive certain funding from the government, and the purpose of your business is the purpose of the nonprofit organization, I'm using the term business widely, the purpose of the nonprofit organization is, I don't know, to perhaps assist athletes, and you are not assisting athletes, but you're paying yourself, you are not acting in the best interest of the organization. You're not acting in the best interest of this nonprofit body. So once complaints are made, and the Registrar General will have to set up the mechanism by which these complaints are made, your registration may be cancelled, and then you would not be able to operate in Trinidad and Tobago. Where the NPO is found guilty of an offense under the Proceeds of Crimes Act, and I would have gone through prior what the offenses are: money laundering, concealing of information, not keeping proper records. The Anti-Terrorism Act, I would not have touched on that, but it exists. The Financial Intelligence Unit Act of Trinidad and Tobago. So remember, I would have talked about persons having multiple charges against them. These would be some of the different framework legislation that would have similar offenses. And if you breach any of those, you would be held accountable. And in law school, they always told us, ignorance of the law is no excuse. So it is your responsibility and your duty to find out what the law is. And as Mr. Latby would have indicated before, if you need guidance, you can reach out to Sport. You can reach out to Sport TT for guidance in this regard. So, are there any offenses for which the controller or the NPO may be held liable? So, the good thing for you right now is that these offenses are not yet in operation because the Act has been partially proclaimed. So only certain provisions of the Act are in force. And I believe that these provisions, if I know the AG well, these provisions will only come into effect because he's trying to give you a transitional period. These provisions will only come into effect after the amnesty period for registration has passed. So sometime after March 31st, 2021. All right? So can an NPO surrender its registration? And by surrender your registration just means, give it up. You no longer want to be registered as a non-profit organization. If an NPO wishes to voluntarily surrender its registration, it may do so by just notifying the Registrar General in writing. Again, the mechanism would need to be determined by the registrar. Within some organizations, it's sufficient to just send an email notifying that, I want to be deregistered. An NPO, which is no longer in operation, must also notify the Registrar General of this in writing. Because if you do not notify the Registrar General will be laboring under the impression that you are a registered NPO, and you may unwittingly find yourself subject to charges and offenses under the Act. So again, the obligation is on you, if you know that you're not operating, to notify the Registrar General, hey, I'm not operating anymore. Now, the register of NPOs is a public register. Anybody could go and search that register. So for compliance issues, Sports TT, if an entity comes to Sport TT and says to Sport TT, yeah, registered, we know how Trinidadians are sometimes tricky Dadians, right? Yeah, register, have my documents, and they give you a false document. There's a public register. There will be a public register where you could go and search to see whether or not this organization is registered. I think it will also have the from when they have been registered. So the register will include the following information in respect of an NPO. Its name, address, its purpose. It would have the name, occupation, and address of the persons who are the controllers. As I said, the date of registration, and the date on which its registration was cancelled, and such other information. So if it's a situation where an NPO comes to you as Sports TT or the ministry, and they say, well, yes, we registered, and then you check the register and you realize, well, yeah, you were registered, but you're no longer registered, that would be a check on your end, right? And that information will be available to the public. That's public information. Are members of the public permitted to search the register of NPOs? So a person who has paid the prescribed fee may, during normal business hours, examine and make copies of or extracts from the register. So it is very similar to the company's registry. So you could go on companiesregistry.com, you could put in the company name, you will search, you will see that this company exists, you will see that it is active. If you want to download the company's information, then you pay a cost. Last I checked, which was about 2 weeks ago, the cost was $20 to download all the company's information. So once you're on this register, so it's public. So what is this doing? This is transparency. This is accountability. So it's assisting with some of the recommendations of the task force. Now, what happens after you submit your documents to the Registrar General's office? According to the legislation, it might play out very differently in reality, but the Registrar General shall within 30 business days determine whether the application for registration should be approved or rejected, and issue to the NPO a certificate of non-profit organization registration if the application is approved. So effectively, this is going to be what's the word that I need? This is going to be a proof that here what I am registered. Right, so this would be one of the additional compliance documents that Sport TT may ask for when the NPO, the nonprofit organization, is coming to the ministry and the company for funding or granting or grants. Right, so it's supposed to be a very quick process, 30 days, just about a month. What is required to be done if there are any changes to the particulars submitted for the registration? And by particulars, we mean in terms of anything, whether it be a phone number change, your address change, you're no longer conducting this type of business or this type of non-profit. So yes, you may start off in the beginning saying that, oh, I want to teach karate in an area, but then you realize not a lot of people interested in karate. You want to use your registration and you want to change your business from karate to providing assistance with respect to dancing, or you want to do community dancing, or you want to do football, whatever it is. You need to notify the registrar, and you have a prescribed form within which to do that, and you have a time frame of 30 days. So you don't sit on it, and you don't wait until you're looking for granting to then go and try and rush to do it. How long is the certificate of registration valid? It's valid for 5 years. So every 5 years, you'll be required to renew your certificate of registration. You'll be required to update the register with information. And a lot of things can happen in 5 years. You have different, well, I think it was Gabriel yesterday that spoke about how often directors change within NGOs, and because when they come in and they get to realize in terms of the amount of work that is done every 2 months, it may change. It's changed pretty quickly. So you will have to re-register, and as I said, update your registration. To renew an NPO registration, you complete the renewal form no later than 1 month after the expiration, and you proceed to pay whatever fee the Registrar General determines. Again, we would have spoke about this before. If non-profit companies are deemed to be registered, are there documents to be submitted to the Registrar General? And the answer is yes. You're submitting whether or not you're a company that is exempt from corporation tax, where the non-profit company was incorporated prior to the NPO Act. Though already deemed to be registered, the non-profit company is requested to submit completed registration form, copy of the certificate of incorporation or continuance, and your photo identification of the controllers. And that, ladies, gentlemen, NGOs, NGBs, would bring me to the end of my presentation. The Registrar General's Department has a lot of information on there in terms of registration of non-profit organization. I said I would circulate the Non-Profit Organizations Act, the Attorney General's website, and if you just do a Google search of Non-Profit Organization Act Trinidad and Tobago 2019, a number of law firms would have done pieces on the legislation. So it makes for quick and easy reading and protection also. So I'd like to thank you for your kind attention, and I would be happy to answer any questions at this time. And I see we have one question in the room already.
Good afternoon, everyone. This is Kevin Garcia from Sport TT. Just some housekeeping. If you have a question, please raise your hand, and then we would refer to you. Raise your hand, Mr. Peters, on the software, not physically. But seeing that I can see your hand, Mr. Peters, I'll allow you in as the first question. So go ahead, Mr. Peters.
Thanks very much. I appreciate the presentation.
Is my TV off?
I am. Yes.
Is my mic on?
You hearing me? DJ? Hello?
Go ahead, Mr.
Hello?
Peters.
You hearing me?
We're hearing you. Go ahead.
Right, good. My whole thing about all of this is public education. We spoke a whole lot of things in the presentation, which was great, but I'm concerned about the public education, that people may not know what they are required to do, and I'm wondering how we can do this. Right? We are willing to do it. I think everybody in this forum are willing to go out and do the education. I just want to know the process, because I know that people are not aware of what is required. And I'm talking from the barbecues right on. So I'm concerned that, how are we going to do this?
Thank you so much for that, President. Again, Justin Npu, George Head, SDPU. Let me just take the question from a couple angles. One, and I think is the most important point I want to draw this morning, the reason that we are doing it at Sport, having brought in Ms. Liverpool and others that will be delivering programs over the next 4 weeks, is to ensure that you are aware. Now, this is a little bit a ticklish one, and allow me to explain. This information has been out there for some time. And from a SDPU perspective, we have been ensuring that we remind all of our NGBs. And President, if you didn't get that reminder, let me know, because I will have to look internally and correct that. But we have been impressing on compliance. This falls under the category of compliance, and particularly as the legislation has been something recent, only partially enforced from 2019, there was a learning curve which they allowed 18 months for all, including sport and all of our partners, to become compliant. So let us use this opportunity now for those of us who are not as advanced as we would like to be, to get our house in order, make sure that we seek the advice that we need, and more importantly, we become compliant. In addition to that, this particular recording will be made available through all of sports social media platforms for all and sundry within the industry and otherwise to have a look at and to make sure they are adequately informed to address the matter. Before I close the mic, I just want to say one more thing though. Please do not be scared and start going and doing mass resignations. Yes, I know that the information was a lot. I thought I knew a bit about it, and I was still sitting here with my mouth open and a few things that were said. This is the reason for this, for us to be aware so that we can make the necessary adjustments and not be victim. As was said by our esteemed presenter, ignorance of the law is no excuse. So let us make sure we have our house in order. I turn it over to the next question.
All right, Neil, I see your hand is up. Go ahead.
Yeah. Good morning, all. Are you all hearing me?
Yes, we are, Neil. Go ahead.
I just wanted to find us some clarity over the certificate for the non-profit organization for NPOs. It says that every 5 years you need to renew the certificate. What I wanted to do, that's inclusive of the NGBs as well, and that from now on, every 5 years, we need to renew our certificate, or are we exempted from that?
Based on the definition of what a non-profit organization is, that would include an NGB. So the short answer to that would be yes. Every 5 years, you would be required to renew your certificate at the Registrar General's department, at the registry.
So, and that we need to become compliant by March 31st,
Coupled with
2021. I could go ahead and further ask.
Go ahead, Neil.
All right, I know that you indicated that we needed to be compliant by March 31st, 2021. Does it mean that from that compliance state 5 years after that, or within that period? I just wanted to know what parameters in which we need to operate by.
It would depend on the date that you register, that you go to the Registrar General's department and register. So if you go, let's say you decide to be an early bird and you go the 28th of February, it would be 5 years from the 28th of February. The deadline in terms of March 31st, 2021 is to allow all the nonprofit organizations or all other persons to register. If you want to go tomorrow and register, you could go tomorrow and register, and your 5 years will begin running from tomorrow. So the date would be depending on when you register and when you have your all of your when you would have submitted all the necessary information.
Okay, thanks very much.
Thank you again for that, Mr. Makano. And I just wanted to add, coupled with that, you have your statutory registration period, which is every 5 years. But based on a comment that, again, Ms. Liverpool brought up, I think it was done actually by our director, Mr. Mitchell, who identified that there's that turnover from time to time at the directorship, which is at the elected level, or even staffing for those NGBs that have staffing. you will be required at that point, and Ms. Liverpool will correct me if I'm incorrect in my position, you will be required to update your, in a sense, your list of members, recognized members, and by members I mean your directors, your whose classes, your controllers, etc., within that 5-year period if you are having changes. So it's not to wait until the 5-year to update that. It is to be updated as those changes occur.
In terms of what Mr. Latibi just said, it wouldn't be in the general membership, but just the controllers. Yeah. So anybody who is the directing or controlling mind behind the NPO, anyone who is doing the management and the administration, the directors, those are who it would be that information that you would need to update. So I see a question from Rebecca Bowler, and she was asking, was stating that her organization was registered last year as an NPO. Is there any required documents that they need to submit annually? Example, annual returns. And the answer would be, it would depend on the nature of your business. It would depend on the nature of your nonprofit organization. As Mr. Latibi just said, if your members have changed, if your address has changed, if you are in receipt of funds in the above $10 million, or above $500,000, then the necessary documents would need to be submitted.
All right, thank you, Delrene. Mr. Roberts, you're next.
Yeah, Joseph Roberts, Trinidad Tobago Cycling Federation. My question is, we are registered under the Companies Act. And with regards to the controllers, I'm making an assumption here, would be our executive would be the controllers, since we are registered under the Companies Act. And I guess I'm just asking the question, so we also are required to ensure when those controllers change, we also update the registration with regards to who the controllers are. Is that so?
That is so to an extent. So you're correct. If you're registered under the company's registry, the Companies Act, sorry, your controllers would be those persons that you have registered as directors. But what is important in this legislation is the definition of a controller, and it expands a little bit from the company's registry, and it includes a person not specified in A to D where the NPO is controlled or managed by that person. So if it's a situation where, for example, because this is a principle we call looking behind the corporate veil. So you may have directors registered, however, the actual control in hand would not be those directors. So for example, I may be somebody that is interested in, I love football. Let's just say I love football, right? But I don't have the time to run the NGO. I, pull up 3 of my friends and I say, Justin, Kevin, Bonnie, I want you all to run this to me. I go and register the organization. I put you all as the directors, but I am the one who is investing the capital. I am the one who is giving the money. I am the one, getting the loans. You all don't know where I get the money from. You all just know you all getting a salary, you're receiving it. I would now be deemed a controller. So it is anybody, another term for it is anyone who has a beneficial interest. It could be a silent partner. The partner may or may not be registered. Those persons would be deemed controllers.
Okay, so in the instance where the certificate of registration at the Companies Act, you have your directors, and you're saying the person behind it, for example, our organization would be the executive who is running that. They would be termed as the controllers.
I heard the last part of the question. I think you're asking again, who would be the controllers? So let me go over who is a controller for you. A controller is a person who has the control or management of the non-profit organization. There's control and there's management. So sometimes you may have registered directors, but they may not be the person doing the operational side of the business of the organization. So it's both those directors who are registered and also those executives who, you might call directors. You call them all different sorts of names. You call them senior officers. They would be deemed to be the controllers. Directors, where the NPO is a non-profit company, is a controller. Trustees, where the NPO is a trust. And what a trust is, do we know what a trust is? So for example, let me see how I'm trying to explain it in non-legal jargon. If husband and wife scenario, so a husband is married to a wife. A husband is married to a wife, right? The husband is the one who working. The husband is the one who getting the salaried income. The husband is the one whose name is on the property, right? So the husband is the one who took out the mortgage. The husband's name is on the property. But the wife, by virtue of her status of being wife, right, would have an equitable interest or a beneficial interest in the house as an asset, because she would have made non-financial contributions. She would have been taking care of the children. She would have been doing activities like that. So the husband in and of himself, though he may have a legal right, he cannot just go and pick up and do what he wants with the property. He would have to consult the wife in law, right? So because the wife has an equitable interest. So what we say in law is that the husband would be holding the property on trust for the wife. So by parity of reasoning, where a situation comes where, let's say someone, God forbid, dies and leaves a certain amount of money to an executor, and then the executor, one condition of the person's will or intention would have been, well, I really like cycling or I really like football, so I want you to give this money to the cycling or the football organization every month until the money finish. Let's say I leave $1 million, I want you to give them $5,000 every month until the money finish. That person will be holding the funds on trust for the NGB, for the non-governmental body, for the non-profit organization. So where you have those relationships and where you have those transactions, that person may not be a director on your non-profit organization. The person may not even be involved in the operations of your business, but that person will be deemed a controller. So what happens now is it will be incumbent on the non-profit organizations to design some sort of agreements and arrangements in terms of operations and spell out certain things very clearly, right? For protection.
All right, I guess that also means be careful what you volunteer for.
Be careful what you volunteer for.
All right, Mr. Pear, I see your hand is up. Mr. Pear, if you're speaking, your mic is off. You can ask your question now.
Right, thank you very much. Sorry about that. Right, great presentation. Just a question playing in my mind. A transfer of player from one club or association or NSO to a club, let's say, in the US or Germany, and a transfer fee is paid. What due diligence must be done with that NSO to ensure that there isn't money laundering or so on from that club?
That is a very interesting question.
Yeah.
I have a lot of questions. You're transferring a player, so you're transferring a whole human being, right? So in terms of due diligence, you need to get some background information in terms of the club, because something I didn't touch on in the presentation, and is a very real issue in Trinidad and Tobago, and that is human trafficking. So you need to have documentation to show, well, why you're transferring the player, what agreements are made between you and this next club, what arrangements are there in respect of the fee. You would need to check to see whether or not the club is actually an established club, it's a registered club. Most likely in these international, within the international jurisdictions, they would have similar registers, similar public registers to us. So you could do your due diligence by checking and not just, transferring the person. But if it is a small fee, just like an administration fee, that may or may not apply. If it's a large amount of money, then you would have to there would have to be some sort of agreement that stipulates why you're receiving this amount of cash and the reasons, all the reasons, the historical reasons in terms of the arrangement between the both entities. So for example, as an attorney, if I am doing a land transaction and a client would pay me, somebody is buying land and a client would pay me the 10% deposit, let's say $80,000 down. When I go to the bank to deposit that money in an escrow account, I would need to carry that agreement for sale between the client and the person receiving the money. So likewise, I expect that there would be some agreement or some written arrangement to that effect. I hope I've answered the question sufficiently.
All right. So thank you for that. Mr. Peters, I'll let you in shortly. We will take another 5 minutes of questions, guys, because we do have another presenter and presentation up next. I'm going to count the 5 minutes from after you answered this question. Define funds for me, because some of these NGBs would receive funding directly from the government, and then they would go out, like I know the Cyclist Federation would go out and also raise funds. Do you have to capture both lines of funding, or is it only the funding that you go out and you seek? And then when you're done with that, Mr. Peters, when she's finished, you can ask your question.
Okay, so I'll have to take it in different areas, right? For interpretation purposes, unless the Non-Profit Organization Act, and I will check, has a definition for the word fund, have a definition for the word fund from what I'm seeing. It would be deemed to be public money. It would actually be interpreted by the courts. So it would be interpreted by the courts. I could speak to different legislation. So I know that the public procurement legislation defines public money and public funds as money raised by an instrument. It could be a loan, it could be a grant, it could be money that has been appropriated by Parliament. It could be when, let's say, a ministry give you money. If you know NEDCO would give you loans, NEDCO would give you grants. All of those things fall under public money. So yeah, those would be that would be a definition of funds. I could do some research on that and give you an answer.
All right, and Mr. Peters, you're next. And remember, guys, even though we're ending this segment at 11:45, please still sending your questions via email. Delrene will answer them post-workshop, and then straight from this, we're going into another presentation. So, Mr. Peters, the floor is yours.
Yes, it was really a comment that with regard to the transfer of players and with specific reference to a footballer. And I think that FIFA would have a say as to whether the club is a legitimate club. I'm just saying, it was just a comment, right? So if you're doing a transfer, you probably could check with FIFA to ensure that the club is a legitimate club. That's it.
Thank you, Mr. Peters. Vidya, you have a question? Vidya, you're on mute, but you can go ahead.
Unmute. Just a little bit further on Mr. Makano's question. So as an NGB, I was registered 10 years ago. I never re-registered. The deadline to register, now seeing that it's more than 5 years, the deadline to register, re-register would be March the 31st?
You're registered as an NGB. So when you say you're registered as an NGB, what do you mean? Do you mean you are registered under the Companies Act?
Yes, I was registered 10 years ago.
Under the Companies Act?
Under the Companies Act, yes.
Right. So if you registered 10 years ago under the Companies Act, we have an amnesty period now where you could go and register before March 31st, 2021 without facing any penalties.
After March 31st, there will be penalties.
That is the assumption, yes.
Okay. Thank you.
The penalty, if I remember correctly, I would have referred to it earlier. I think it was $500,000 or $50,000. Let me just flip back quickly in the slide. I think it would have been $50,000. Okay, something came to mind while Kevin was speaking. You know, sometimes, a lot of times we ask about, you know, what is the penalty if we don't register? To be honest, the penalty, even if the law doesn't, the long hand of the law doesn't catch you, the penalty will effectively be if Sport TT and Ministry of Sport is doing their, you know, due diligence, you would not be able to get funding, you would not be able to get assistance, you would not be able to get a grant. So that would be the penalty in a nutshell, because the focus really is on getting you to be compliant. Nobody wants to put you behind bars, you know, and nobody will put you behind bars. You will be the one to put yourself behind the bar because you are not being compliant. And with those few words, you know, I would like to just close by saying it was my pleasure presenting to you today. And thank you for your participation, and thank you for those very keen questions. And I look forward to working with you going forward. Thank you very much.